hedge funds, honed in on a single hedge fund, Galleon, isolated only me, its CEO, who had recently become one of the few immigrants on Wall Street to be identified as a billionaire, and built a fabulous and intricate tale of sex, drugs, and rock and roll to entertain the public and build their own reputations. Their 2-year reality series was successful beyond measure. Preet Bharara, then the U.S. Attorney for the Southern District of New York, SDNY, used my prosecution to launch an unprecedented press campaign to promote himself. Bharara ran roughshod over the truth, standard DOJ protocols, and the office's own dignity in his extraordinary zeal to convict me. Time magazine put Bharara on its cover, their headline proclaiming, "This man is busting Wall Street." It was Preet's finest moment. Bharara did not touch the real perpetrators of the 2008 financial crisis, Wall Street's top bankers. In 2014, in a rare moment of sheepish public acknowledgement, both Bharara and the influential New York Magazine observed that the insider cases made our careers, but they didn't change the world. Bharara's impotent and poisoned approach to the non-prosecution of criminal activity on Wall Street, ranging from the mortgage bankers who precipitated the financial crisis, Goldman Sachs, Lehman Brothers, the money laundering of drug cartels, HSBC, and the encouraging of tax evasion by U.S. citizens, UBS, CSFB, is now the defining legacy of his tenure. Each of these firms settled civil charges by paying billions of dollars in fines using shareholder money, but not one single person was criminally charged or individually fined. Every one of the insider trader prosecutions was criminal. The towering hypocrisy remains startling. The prosecution, under Bharara's watch, advanced a theory of trading to prosecute me and several others that the appeals court of the Second Circuit subsequently overruled, criticizing it for doctrinal novelty. Soon after my trial in May 2011, then Commissioner of the Securities and Exchange Commission, SEC, Mary Shapiro, gloated that the beauty of insider trading laws is the flexibility in interpreting them. The lead prosecutor in my case, Jonathan Streeter, said in December 2012, "Insider trading cases are confusing to investment professionals." He went on to add, "There is incredible confusion on what is illegal, and it's a real problem. The law is very complicated and the lines are a bit murky." A U.S. attorney, the prosecution in my trial, and the head of the SEC all acknowledged their reservations about a murky set of laws, but had no murky reservations using them liberally in my case and at my trial. The FBI agent overseeing my case, Special Agent King, lied on his sworn affidavit to obtain wiretap authorization of my phone. Recognizing there had been government misconduct, Judge Richard Holwell, who presided over my trial case, issued a searing criticism of the wiretap application used by Agent King, reprimanding him for reckless disregard for the truth with respect to both probable cause and necessity. The judge went on to add that false and misleading statements and omissions pervaded the affidavit submitted by Special Agent King so extensively that it was impossible for the authorizing judge to have the constitutionally required determination for the issuance of the wiretap. Rather than provide a full and complete statement as required by the law, the wiretap affidavit made full and complete omissions and included literally false information. King did not stop at blowing through truth on paper. He menaced and threatened my family and employees with prosecution, frightened away crucial defense witnesses, and routinely leaked false information to the media, churning up an unabated feeding frenzy that shredded me in the court of public opinion. King took his cues from the playbook of publicly reviled former FBI Director J. Edgar Hoover. I was tried, convicted, and sentenced in the press even before I